Hi, my name's Stuart Salwin, and I'm a criminal defense attorney here in Scottsdale. And in this video, what I'd like to do is discuss the crime of unlawful discharge of a firearm in Arizona. And this is defined under Arizona law under statute ARS 13-3107. Another name for this law is Shannon's Law, due to an accident that occurred in Phoenix back in the 90s, which created unlawful discharge of a firearm as a felony offense as opposed to a misdemeanor offense. Essentially, this crime occurs when somebody fires a gun within city limits, besides for it being in a designated gun range. And the actual crime is a bit more complicated than that, and we'll get into the details of that later on in the video. But essentially, firing a gun in the city is what this law prohibits. And this law doesn't require anybody to be hurt. It doesn't have to involve the gun endangering anybody. That can happen, and it might result in additional criminal charges. But it's not required for there to be a violation of this law. All that's required here is for a gun to be shot. And the idea behind this law, and the reason for making it a felony, is that if you have a stray bullet in a well-populated area like a city, whether the bullet goes up in the air, goes across the street, or through an apartment wall, that bullet is going to wind up landing somewhere or getting lodged somewhere, and people can obviously get hurt in the event that they're hit by one of these stray bullets. And while that may be unlikely to hurt anybody on any specific occasion, the concern is that if in the small percentage chance that it does hit somebody, the consequences there could be irreversible. And so the law is a felony, and it comes with harsh potential punishment. One of the reasons that the potential punishment is so harsh as well is that almost always, when this type of crime is charged by the prosecutor, it will be charged as a dangerous offense. And what does that mean? Well, there are different types of ways that crimes can be categorized. A crime can be classified as a regular felony, and the key about a regular felony is that if you're a first-time felony offender and you get charged, then you're eligible for probation if you're convicted of the crime. You may be sentenced to prison, that's in the judge's discretion, but you may also be sentenced to probation. When a crime is designated as a dangerous offense, though, probation is not an option if you're convicted. If you're convicted of a crime that's classified as dangerous, then the judge has to sentence you to a term of prison, even if this is the first time that you've ever committed a crime. There's simply no leeway for the judge to sentence you to probation. And this is because a dangerous offense is a crime that involves the use or discharge of a deadly weapon, and a gun is obviously the classic example of a deadly weapon. So unlawful discharge will be able to be classified as a dangerous offense in almost all cases, because by definition, it involves the use of a deadly weapon, a gun. So the big problem if you're facing a case where you're accused of unlawful discharge is that the county attorney has likely charged it as a dangerous offense. So you are looking at mandatory prison time as a punishment if you're convicted of the crime as it's charged. Now, let's talk about this crime in a little more detail. So first, the exact definition of the crime is a bit different than how I've been describing it so far. It's a bit more technical, and that can make a difference depending on the facts of your case. So the exact definition of the crime is that unlawful discharge occurs when a person with criminal negligence, and pay attention to that phrase, discharges a firearm within or into the limits of any municipality. And a municipality, that's just another word for a city or a town. So the crime isn't just about shooting a gun in a city, it's about doing so with criminal negligence. So what does that mean? Well, criminal negligence under Arizona law is a type of intent. There are all different types of intent for criminal activity. Some crimes require the state to prove some types of intent, and other crimes require the state to prove other types. And so some types of intent are called intentional or knowing. Intentional is when you actually want to do something. Knowing is when you do something knowing that a result will happen even if you don't really care one way or the other. Another state of mind is recklessness, and that's a level down from knowingly doing something. Doing something recklessly essentially means that you know there's a risk that a certain outcome will happen, but not caring about it and not having any justification to taking that risk. This might be if you're, let's say, twirling a loaded gun around with your fingers and then it accidentally goes off. Well, that would likely be reckless because you didn't know for sure that twirling the gun would result in it accidentally being discharged. But a reasonable person would know that the gun accidentally going off would be a risk, and there really isn't any circumstances that would create a justification for taking that type of risk. And now below that, and this is the lowest level of intent, besides for a strict liability crime, which doesn't require any intent at all, is the minimum level of intent that's required for unlawful discharge of a firearm, and that's criminal negligence. Criminal negligence requires the state to show less intent than any of the other levels of intent we've discussed so far, but it still does require some level of intent. And this occurs when a person fails to perceive an unjustifiable risk, which is a gross deviation, so not a minor deviation, but a very big deviation from the ordinary standard of care. Meaning, if a reasonable person usually does an action in a certain way, and you're doing that same thing in a much worse or more dangerous way, even if you don't perceive that risk or know that you're doing something in a really bad way, well, then that would constitute negligence. So an example of this might be, let's say you're trying to clean a gun, and cleaning a gun is totally fine by itself if you're doing it the proper way. There's nothing reckless about just the act of cleaning a gun. In fact, if you own a gun and you use it, you probably should. So let's say, on the other hand, that you think you know the right way to clean a gun, but you really don't. And you actually start to go about cleaning the gun in an unsafe way. So you might not perceive the risk yourself because you don't know how to properly clean a gun, even though you think you do. But a reasonable person who knows how to clean a gun would look at you and say, you know, you shouldn't do it like that. And this causes the gun to go off. Well, that could constitute criminal negligence. Now, for unlawful discharge of a firearm to be proven by the prosecutor, he doesn't have to show that it was only criminally negligent. The action might also have been reckless, or it might have been knowing or intentional, all the way up the scale of intent. But if it's any of those, then it's also going to be criminally negligent to do so. So going into an open field within city limits and firing a gun for target practice might be intentional, knowing, and reckless, but it's also criminally negligent. And criminal negligence is all that the state has to prove. Now, there are some exceptions to this law that are actually written into the statute. There's a total of 9, and I'm not going to discuss all of these in depth here, but if any one of these 9 exceptions apply, then the offense of criminal discharge has not been committed. Unlawful discharge is classified as a Class 6 felony offense. And a Class 6 felony, if you have no prior felony convictions, is probation eligible as long as it's not classified as a dangerous offense. But as I mentioned, unlawful discharge will almost always be classified as a dangerous offense. If you are a first-time offender and you're convicted of a Class 6 dangerous felony, then you're facing a minimum of 1.5 years in prison. The maximum sentence is 3 years of prison, and the presumptive sentence, which is the default sentence, all other things being equal, that is 2.25 years. So I don't think I need to tell you that you need to take this seriously if you're being investigated for this crime or if you've already been charged with this crime. But does this mean that you're going to go to prison if you're facing these charges? Well, luckily, no. It doesn't necessarily mean that. Now, every case is different, but I can say that in the unlawful discharge cases that I've defended, I've, in many cases, been able to get some really good outcomes for some of my clients. And depending on the circumstances, the prosecutor may even be willing to offer a diversion plea. A diversion plea is an agreement that ultimately can result in your case being dismissed entirely. Now, if the facts are more serious and maybe people's lives were actually in danger, sometimes a diversion plea might not be possible. But even in some of the more serious cases that I've handled, I've been able to secure pleas for no jail time for a Class 6 undesignated felony. This means that after the defendant successfully completes probation, then the case will be designated a misdemeanor. So no felony conviction will ultimately wind up on your record. Other cases I've worked on have involved people calling me during a police investigation when charges haven't yet been filed. And in some of those cases, we've been able to keep criminal charges from being filed against the client entirely, which is, of course, a great outcome. Now, if you're facing these charges, this isn't to say that this would be the result in your case. Every case is different, and this is just some examples of what I've been able to accomplish for some of my clients in the past. And it shows you that even if you do get these types of charges, your situation's not hopeless. There are things that can be done to try to improve your chances of a favorable outcome. Perhaps there might be some problems with the state's evidence, which could lead to reasonable doubt as to any particular element of the crime. And there might also be what are called mitigating factors that are important during negotiations. These are things about you that show that you're a good person and that can create some sympathy for you, which can be used to try to negotiate a good outcome with the prosecutor. The best way, though, to get a better understanding of your case and what you might be facing is to speak with a criminal lawyer about the specific facts of your case. I hope you found this video helpful. Give it a like if you did, and if you do have further questions about criminal charges that you might be facing in Arizona, and you'd like to speak to an attorney about your case, then please give my office a call. The phone number is in the description below. We offer free consultations on criminal defense matters. Thanks for watching.